Good morning, good evening, good afternoon. Welcome to Common Sense Not So Common, this podcast series examining risk, commercial judgment, claims, and dispute resolution. Today we have a very special guest, Keith Kelliher, one of Ireland's leading voices in construction adjudication and dispute resolution, a practicing adjudicator, trainer, and construction professional. He's been a strong advocate for fair, efficient, and accessible dispute resolution within the industry. Before we move on, Keith, I want to ask you, how did you find your way into adjudication and construction dispute resolution? Tell us about your journey.
Well, let me start by thanking you for the invite to come on. It's a pleasure to be here. My career, I suppose, from the very start, ended up in the dispute world, and I suppose so. There's an element of luck, I have to say, with how I suppose ended up in the space. My very first project was the construction of the M50 motorway, which is kind of Dublin's kind of main artery motorway that goes around the city. And one summer prior to me going to college, where that job was starting wasn't far from where my mother's house was. So I went up one day to see if I could get a summer job working on the motorway for the summer before I started college. And I got a job as a chain man, and kind of within the first week, I was sitting having breakfast with, in the compound with everybody. And the quantity surveyor for the project was sitting there having his breakfast, and he was just chatting, how's everyone, what are you doing in college? And once I said quantity surveying, he effectively said, right, you're working with me now. And that project went on for a couple of years, but it ended up in conciliation, which is what we predominantly use, particularly in our infrastructure and our public works contracts. The go-to method of dispute resolution is conciliation, which I know is not massively used in the UK, but it's for those who don't know what it is. It's a kind of mediation first with a bolt on of a kind of a recommendation at the end in case the mediation doesn't settle. So that process went on for about a year on that project, and we were heavily involved in it. And then I left that project, went to another project that ended up in conciliation as well. So whether it was me causing all of this or whatever, I literally was in the dispute space from the start. And I just found it kind of, and I say this to lots of QSs when we're giving seminars and whatever to young surveyors, like, the skill set of a quantity surveyor is so perfect for dispute resolution that you do find that, a lot of your training as a QS, you're using that skill set. So it kind of comes quite naturally. And where it comes most naturally is in adjudication, because obviously, in Ireland, we're only allowed to adjudicate payment disputes, which is slightly different again to your legislation in the UK. But obviously, as a QS and payment disputes, again, it comes naturally. So it's just natural progression through finding myself constantly in disputes and having to find a way of getting around them, I suppose, is how we ended up here.
So, how's conciliation now? Because I know there is a lot of concern you've raised recently about statutory adjudication in Ireland. So what is happening? What do we need to understand about it?
Okay, so our legislation was introduced. It's called the Construction Contracts Act 2013. Was introduced to deal with it. It had two purposes: to regulate payments in the construction industry and to introduce adjudication into the market, but only, as I said, for payment disputes. So the legislation came in 2013, but it only commenced for projects that's commenced after July 2016. So we've had it now for 10 years. And so we don't have approved nominating boards. We have a single panel which sits in what we call the minister's panel, which is administered by a department of government. Okay. And the panel runs on a 5-year cycle. So we're at the end of the second cycle because we're literally 10 years. And unfortunately, what we found is And I suppose this is the problem by, I think, not having nominated boards, is that you don't have kind of constant progression and constant change and cycles. What happened was the panel lapsed, and the panel was allowed lapse. So we had a 38-day period where we had no adjudication panel at all in Ireland. And that came about because people didn't do their jobs. There's no other word you can use, but whoever was responsible for ensuring that whatever system was put in place to, start the process for the next panel never started in time, and the previous panel was allowed lapse. So we had a 38-day period where we had no panel at all. And then there was a process to get a new panel, and they reinstigated a panel of 19 people. And all of a sudden, the chair of the panel then lapsed. So we had 38 days with no panel at all. We then had about, I think it was from the 17th of June, we got our panel back. And on the 30th of June, the chair of the panel's appointment lapsed. So we currently, and we are now on the 29th of July, and we currently have no chair of the panel, and have had none since the 1st of July. So we have no chairperson of our panel to appoint anybody if anybody comes looking for an adjudicator. So we're at a bit of a standstill in adjudication as a result, and that's obviously a big problem, because it's an access to justice that so many of our industry have sought to rely on. Given how quick it is, and that just to save their businesses. Conciliation is kind of it's a more long-winded process. Like it's obviously a voluntary process. Parties engage in it, and if they don't succeed in finding a settlement, conciliator issues a recommendation, but that recommendation can be rejected within a set period of time, and then the parties move on to another process. So it doesn't give you that kind of temporarily binding but still binding decision that adjudication gives you. So it is a fundamentally different process. But look, I look at them all. I sit in all the different seats, and I look at them all as tools in a toolbox, and it's a case of finding the right tool to unpick the right lock. And but that lock of adjudication at the moment is well and truly locked, and we're struggling to open it.
So effectively, since May, there has been no access to statutory adjudication.
Other than for about from the 17th of June to the 30th of June, in that very small window, a number of cases would have got up and running. But yes, other than that, since May, I was on the original panel. I think it was the 9th of May we timed out. So since the 9th of May up until today, other than that small window, adjudication has been off the table.
So you mentioned access to justice,
yeah,
which basically is saying to me that legislation is there, so the overarching, statutory optimization is there, but the problem is an administrative issue.
Yes. The simple answer is yes. There is no. If there is more than administration at play here, it's been done in the background and nobody knows about it. Like if it's if it's some form of attempt, which could only be at government level, at stopping adjudication taking place or something, like there's no evidence to suggest that that's what we're talking about, other than it being an administrative issue. So it's bizarre. Because they did have the power to simply extend the period of the previous panel. They did have the power to extend the term of the chair, and they've chosen not to. I can't answer why that is.
Yeah, of course. How serious is the problem in practice?
See, it's like anything. Like, so if you're a business, so I had a phone call. And this is why it's a problem. I had a phone call from a prospective client, and lots of our clients will come to us, and we'll only ever deal with them once, because we'll fix the issue, and then we hope they learn from that issue and don't come back to us again. It's not mine is not a business that people come in all happy and, joyful. So we try and keep people out of it. But I had a phone call from a client who was indebted to a business for in the tune of €600,000 and had paid out over 3/4 of that money to subcontractors and could not get engagement with their client at all in regard to that sum. So they paid out over €470,000 of a €600,000 debt. And they came to me because someone had recommended adjudication. They'd never heard of it. For me to have to turn around to that person and say, I can't currently help you, is a massive problem in the context of where does that person go? Do they go to the court system? Are they going to survive the 3 to 6 years that's going to take to get that case through court? Are they going to go to a conciliation system that has no guaranteed outcome, that can't force a resolution, particularly if the other side don't engage? It's that removal of that access to justice, which has become a lifeline to lots of businesses that didn't have any lifeline. Like before adjudication came in Ireland, we had the Celtic Tiger crash, and business after business went to the wall with nowhere to go to have issues resolved in a quick period of time before they went bust. So adjudication was seen as the answer, and we've now taken that away for no reason, and we've removed that. And so when we talk about how big a problem is it, it's a problem for those businesses that need it today. It's like an ambulance. It's like ringing 999 for an ambulance and finding there is no ambulance. Nobody talks about it until they're the one who's picking up the phone to ring the 999 to find there's no ambulance and they need it. So that's kind of what adjudication to me is. It's the phone currently. There's no one answering that phone for the people who need to ring it, and we don't know the impact of that yet. But if it goes on for much longer, I have no doubt we're going to start seeing businesses failing that wouldn't have failed if they had access to it, and that's the problem. And I think it's important. I always kind of think we have to distinguish between what the majority of people's views of our industry is, which is the top tier of contracting. Most architects, engineers, a lot of them, they operate up in the top tier. So their view of the industry is the top tier and what happens up there. That's not where our market is. That's not where our industry is. Our industry is made up of family businesses where the father and the son work together and the daughter is the accountant and the mother keeps everything together. But they're also employing 6 or 7 of the lads off the local GAA football team. So when that business gets into difficulty, it impacts the whole of that village because there's numerous families impacted by it. And that's the bit that I'm always concerned about. Yes, we've a concern for the bigger companies because of the knock-on impact of a failure at that level, but there's thousands more companies operating on tight margins, earning a living on the lower end of the market, and they are the people that adjudication is a lifeline for because they can't go to court cases and they just won't survive. They don't have the time, they don't have the resources to do that. So it's I'm hoping nobody's impacted by this, but common sense would say that's not the case.
I agree. Adjudication has been a quick, independent, enforceable dispute resolution system in Ireland for as you said, for a decade. And if parties now don't have access to it when they have finally gotten used to using it for their payment disputes, I think the industry confidence naturally gets damaged, and it will take some time to rebuild that confidence. So, in the meantime, as you said, you had a potential client discussing it. What are parties doing in the meantime?
Um, in certain instances, you're quite limited because the unfortunate nature of disputes, and particularly when I see a dispute as a natural occurrence in commercial operations. And I distinguish that between how you deal with a dispute decides whether you get into conflict or not. Conflict being a more costly, aggressive thing to fix. But when you're in dispute, a lot of people, and I don't know if this is just an Irish mentality, if they know that there's nothing the other side can do, if they know there's no string the other side can pull, quite often you just get radio silence. So you just get ignored. And there's not a lot you can do in that context. Now, that's not a one size fits all, but unfortunately, the part of the market I'm in, I regularly call the cesspit of hate, because it's the part of the market where, like, we don't see people doing the right thing. If people do the right thing, I don't have clients. So, like, what we try and do is open avenues of engagement, try and see will people, open the avenue of mediation. But we are finding that because so many people know that adjudication is roadblocked at the moment, that we're just getting radio silence. So, so you're trying, but, it's a bit like going to a gunfight and the person on the other side knows there's no bullets in your gun. Like, that's effectively where we are.
I'll give a comparative example. I mean, for example, adjudication in the UK is not just limited to payment disputes, whereas in Ireland it has been. What is the general view of the industry? Should it be expanded? Does the current scope work? How people resolve their disputes outside of payment?
So there was a view. So the Irish legislation, we said, is 10 years old, but largely nothing happened in the first 5. You could nearly disregard the first 5 years because there was very little use of it. We had no real court cases. So we didn't really learn anything from the first 5 years. We've learned everything in the last 5. So there was a case in Ireland in November last year, October, November last year. It's what we call the Connaughton and Irish Timber Frame case, okay? And prior to that case, pretty much we would have all taken the view, sure, everything's a payment dispute. Like, we would have people who'd say, sure, if you're any good as a quantity surveyor, you'll turn everything into a payment dispute. And that was largely the way the industry was working, right? So we were kind of like, you make a claim, it's rejected, there we go, payment dispute, and on you go, okay? And that's kind of what we were largely doing. Now, we were kind of ignoring quality disputes and different things like that. They weren't really popping up as issues. But we had this kind of like, sure, what's a payment dispute? Because we didn't really know what it was. In the Connaughton case has confirmed that the view of the courts is that a payment dispute is a dispute that arises under the contract, right? So what that did was it precluded people from claiming, let's say, damages arising out of repudiation, which was probably the biggest item that we would have seen adjudicated that is now not classified as a payment dispute. So like where someone repudiates a contract and then you're claiming your loss of profits and damages and whatever else, people were just sending that in as a payment claim. It was rejected, payment dispute, onto adjudication, and the adjudicator was deciding it. And in the Connaughton case, that's exactly what he did. But the other side challenged enforcement, and the court looked at it and said, that's a common law claim. That doesn't arise under a contract, so that can't fall under the definition of a payment dispute. So we had a lot of debate about this as to like whether the term payment should be removed. And I think I've never really heard anybody say that it shouldn't. I'm trying to think, and I can't think of ever having heard anyone who kind of fights for this idea that we only confirm it or confine it to payment disputes. So I think the entire industry would like it to be as wide as possible. I've never heard anybody say otherwise. Now, the Connaughton case is currently being appealed in the Court of Appeal. And the appeal was actually heard back in April, but we haven't heard the outcome of that. But like if that case comes back and says no, that the original judge was wrong, well, then it may very well be that our legislation does cover wider than payment disputes, in the context of what is a payment dispute. But look, most of us would have said from the start, why did we put this word in our legislation? Like, what was the purpose of confining it solely to that? And we've never really got that answer. But outside of that, people are conciliating, mediating, Not really a lot of arbitration in Ireland, domestic arbitration. There's a lot of international arbitration that's held here, but there's not a huge amount of domestic arbitration anymore. So really conciliation, mediation, negotiation and expert determination, but not at the level it should be. Like, it's the most underutilized tool in the toolbox that we have, I think, to be fair.
That answers my kind of misconception on adjudication in Ireland. Because if there is a quality dispute, I wanted A, B, C, but I only received B and C, I didn't receive the quality that I wanted, and now I don't want to pay you. So that turns itself into a payment dispute. But at the core of it, it is actually a quality workmanship issue.
I agree with you. Yeah.
But it still will be adjudicated as a payment dispute.
And this is where the Connaughton case has kind of thrown a curveball to the industry, is because, so let's take that exact example, but let's look at it in the context of an oral contract. Okay. So you have an oral contract where you entered into an agreement to build something, where you discussed the quality that you wanted, and the parties agreed, and you moved on. Now, our legislation does cover oral contracts, but how does it arise under the contract? How do you argue as to what the quality was in an oral contract when you take a case that's telling you effectively the dispute must arise under a clause in the contract? So you don't have any clauses. So these are the curveballs that we're trying to deal with, as to, in that context, is a quality dispute a payment dispute? Whereas in another dispute, you might have a contract that specifically has a clause on quality, that does have a requirement to follow some sort of workmanship level or whatever. So therefore, there's at least a clause in the contract, and there might also be a set-off right and whatever else. So the quality quite easily in that context can flow into a payment dispute, whereas in an oral contract, not so much. And that's the difficulty that we're having. I suppose you have to remember, you're 30 years ahead of us in terms of your knowledge, in terms of your development of your legislation in the UK. We're only in the first 5 years. And I suppose we're trying to find our feet with what works, what needs to change, and the likes. I think where the downside is, we didn't learn from the UK. And it's clear we didn't learn from the UK. You remember that when our legislation was being drafted, it was about a year after you had revised yours in 2009. So
yeah, Construction Act 2009, yes.
Yeah, so the first draft of our bill was done in 2008. Okay. It didn't come in, it didn't become a bill in Ireland till 2010, and then became the 2013 Act. So we could have just looked at the changes you had made, because there's a couple of main problems with our legislation, and the Connaughton one was one. But the whole issue of what happens if no one issues a response is an even bigger one. So if you don't issue a response to a payment claim, in Ireland, our legislation is silent on what happens. So nobody knows what happens if you don't issue a response. And this is a legislation that was drafted after you had made your changes in 2009 to directly, I suppose, fix the misconceptions on that issue in your legislation. And we didn't learn from that. And, it causes problems today,
Wow. So I'm going to ask you about the current system. And we know adjudication has been kind of not happening over the last 2-3 months, except for the time between 17th June and 30th of June. But if there is one thing you would want to change in the current system, what would it be?
Well, it would have to be to what I just said, I suppose, in regard to the absence in our legislation of a consequence for somebody not issuing a payment response within the 21-day period. So, like, I go back. So our legislation is titled an Act to Regulate for Payment in the Construction Industry and for other matters. And the other matters was bringing in adjudication. But the Act's primary focus was on correcting the misbehavior in payment in our industry, which was notorious pre this legislation coming in. And, often someone would have made a claim for, say, 200 grand, and they'd receive 25 grand into their bank account with no understanding as to what the 25 grand was for. And so when the legislation came in, you had a system, no different than your scheme. We had a system.
Yes.
You make a payment claim notice, you get a response. The response must issue in 21 days. You obviously have a line in your legislation that says what happens if that response doesn't come. Our legislation, that line was removed. Now, that line was in earlier drafts of our legislation, but it was removed. So our industry operated for the last 10 years on the threat of smash and grab, right? So because it was a threat, nobody really knew, is it implied that that's what happens, or what happens? And, so because of that, behavior improved hugely in our industry. People were responding for fear of getting hit with a smash and grab. And unfortunately, in January of this year, we had the tender bids case, which overturned that on the basis that it provided the clarity. Somebody challenged a smash and grab award, and the court basically said, our legislation doesn't have a consequence. We can't imply in a consequence. So there is no consequence. And if you want the consequence, you have to put it in your contract. So that's the one piece I would like changed. And the reason being is that in Ireland, and I don't know if the UK is the same, but in Ireland, there's a massive percentage of work done in the Irish construction industry that has no contract at all. Now, when I say contract, I mean written terms and conditions. It has no rule book. So it's all well and good saying to a market, if you want to put in a consequence for smash and grab or whatever, put it in your contract. But the market don't have one of those in the first place. A lot of the market. So that's not the answer. So the answer would be to have that issue corrected in our legislation and in a redraft of our legislation, along with a few other things like the payment dispute and a few other things. So that would be my desire. I just don't think the political will is there to look at this legislation at the moment, and so I don't know if we'll get that.
I've been looking at the statistics of the growth of adjudication in Ireland, and over the last 8 years, it shows a significant growth. So you're right. In the first few years, nothing happened. I think since its enactment, I think about 8 years ago, there was just one adjudication.
Yeah.
Last year data suggests there were over 101 applications and 93 appointments.
Yeah.
Now, in comparison, the UK data from the Adjudication Society suggests that there are over 3,000 adjudications every year. A significantly large number, of course, significantly large population mass as well, if we look at per capita or per project suggestion. So I understand the growth has been significant, and just as the system, the confidence in the system is growing, we've now seen the interruption in appointment. In the UK, we have adjudication nominating bodies taking care of this. How can this be done in Ireland?
The initial view was that because our market, so if you take the statistics versus population, we have a similar use of adjudication as you have. If you take it, so we've only a 5 million population. Yeah. So if you work those stats, and lots of people do this because we do use the UK as a kind of a barometer, even though we might pretend we don't, we do on a regular basis. But so we're using adjudication the same, but the view in Ireland was, because our market was so small, and it is a very small market, that having kind of loads of nominating bodies, or the right effectively for anyone to invent a nominating body tomorrow and have panels, and that effectively you could end up with 5 different lists of the same names of people, or you might just not have it at a standard that kind of was acceptable. And that's why when they were doing the legislation, they felt for the size of our market, it made more sense to just have one panel that was kind of a controlled panel, and that you to achieve certain qualities and you had to have certain qualifications to get on that panel, and that was felt that was the answer. I think I agree with the logic, but I think what the last couple of months has shown is that, it doesn't mean it works. It doesn't mean that, like someone actively is governing it, or someone is taking ownership of it, which would happen in the private industry, because or an institute. Like if an institute was running the panel, this wouldn't have happened. Like it's as simple. This would not have happened. Like heads would roll if something like this was to happen. It would be embarrassing. It would be, the negative view of adjudication from outside Ireland of our system must be horrendous. Like people, like look, and I operate in the UK. I have lots of connections in the UK. I know a lot of the people operating in the ADR space in the UK, and they look at Ireland as a basket case at the minute. Like, and there's nothing I can say to stop that, because it is like this is illogical, and but I don't think it's a reason to pull the plug on our system. I just think people need to be accountable for their roles, and they need to understand the importance that this process has on a market, and give it a bit more care and consideration than you've been giving it up to now, because this is just not acceptable. But I don't know. I don't know what the answer is.
No, it's let hiccups come everywhere. It's about how we come out of it to the next stage. And now I'm painting a picture. Everything is fine. Adjudication is working. People hopefully don't have payment disputes, so they don't have to come to adjudication as much. I mean, that is the ideal world. But as you said, disputes are inevitable.
Yeah.
It's one of those things which happen, because I'll go back to the dictionary definition of disputes. It's a misunderstanding between two or more parties. You can't have a misunderstanding with yourself. So that would be wrong, very wrong. So let's come to you mentioned a bit about getting onto the panels and adjudication. So a point that we cover a lot is for young professionals looking to build a career into ADR. So let's just look at the adjudication perspective. A lot of people who work in construction aspire and see it as a very fulfilling career. So how do they go about becoming an adjudicator?
Yeah, like the way I started with it, I never actually aspired to be an adjudicator, and I probably ended up being an adjudicator a lot earlier than I'd ever envisaged that coming about. I enjoy the battle, and I think for anyone, and the biggest mistake people make coming into ADR, and it doesn't matter whether they're young starting off, or whether, as we know, a lot of people kind of retire into the space from other areas. And I think the biggest mistake that a lot of people make is that they don't enjoy it, and they don't understand it. If you don't enjoy the cut and thrust of disputes, it will live in your head, and you won't enjoy it, and you'll eventually leave it, or you'll just run away from it. So you have to enjoy what you do. So the best way I've always felt, and the way I built my business, was getting involved at the ground level as an advocate. So providing a service to people in dispute who would never go to a solicitor, who would never go to a barrister. And there's lots of them, because they see that as just cost. So there's a big gap between where there's lots of disputes, and they mightn't necessarily, and the solicitors would be the same, where they'd see a certain value of a dispute that doesn't pay them to run, because they can't make the fee work for their client and themselves. So there's a massive amount of disputes in the construction industry that need advocates for. And so that's what I jumped into day one. And what that does is It's enjoyable. You never get a win. Have you ever, as an adjudicator, sat there in the office and went, yes? No, you haven't. And the reason being is because you already know the minute you issue this decision as an adjudicator in a very lonely place is that 50% of your audience are going around the industry saying you don't know what you're doing, and the other 50% think you're a great human being because you've gone with them. Now, some people will take a more rational approach and say, you know what, we lost, but we understand why we lost because it was well reasoned and whatever else. But it can be a lonely place. As an advocate, you get wins, you get losses, you learn with every single file. You see the style of every different adjudicator. You see how this adjudicator dealt with that, how this person dealt with it, what their style is, how they reason, everything. So your learning power is massive as an advocate because you see multiple teachers. Every time you have a case, you learn from that. So when you aspire to be an adjudicator, live in the process, like getting your feet in the trench, fighting the fight, understanding the contract, understanding what it takes to convince someone. What does evidence actually mean? Why do we say records? Like, what does that mean? Why is it important? You learn all that as an advocate. So like get the 200 or 300 cases under your belt as an advocate. You'll be the best adjudicator that the industry will want you. They will desire to have you as an adjudicator because your knowledge base and your expertise will be unmatched. And that's what I did. And I did that from day one. I do probably the majority of adjudications in Ireland as an advocate. I do the highest amount, I would think, and I've been told off the panel every year. So even though I'm an adjudicator, I love advocating. My business is an advocating business. It helps parties resolve disputes. It uses the tools available. And that's the best route for anybody aspiring to get into the market is learn from the ground, look at the experts in the field, look at how they do it, learn from them. You'll also get every single template you need given to you by all of the top adjudicators because you're putting cases in front of them all the time. So you learn style, reason, and aptitude, everything you need to do. You see how people manage processes. So you see everything from being and living it. And that's to me, is the only way you should do it.
I'm going to start some quick fire questions now.
Okay.
Do you think common sense is common?
No.
Okay. You've seen hundreds of payment disputes, but behind it, there is another symptom. What do you think is the most common symptom?
There's two. So if I can answer, okay. There's two. One is paper. So that's because just paper, when we talk about passing risk, so contracts, minutes of meetings, all of that stuff, there's so many disputes just come from our lack of time and clarity that we put in paperwork. Okay, so paperwork, I call these the two causes of all disputes, paperwork, and the other one is what I call cabin politics, which is humans interacting with humans, coming at things from different places. I'm a young QS and I need to climb on top of you, Mr. Subcontractor, so I can show my bosses what I can do. All of that stuff. They're the two. Cabin politics, which is humans, and paper, are the two causes of every dispute that's ever been on my desk.
I agree. Poor contracts, poor records, leading to poor communication, and ends up that we just cannot have difficult conversation on a table.
Absolutely.
Yeah. And this is a very difficult issue that drives the wrong behaviors.
The communication one is massive because, and I do say this, and lots of people in the IT world give out to me because they think I want to live in the dark ages when I don't. I love technology. We all use it. It's done wonders for us. But with the advent of technology, we have to be very careful as to how we effectively communicate. Like when we were created, we have 2 ears and 2 eyes. We've 1 mouth. So what does that tell you? That tells you that whoever invented the human being believed that we need to see and hear twice as much as we spoke, because he only gave us one mouth. What the internet and a lot of these portals and our communication systems are doing to us is they're preventing any form of communication, through human interaction. So we're just sending mail bombs at each other. We're sending notifications at each other through a portal, but we're not meeting each other. We don't meet anymore. We don't sit there. We don't trash out problems. So communication is why it's not the cause of disputes, but it's what drives pretty much all disputes into conflict is the fact that we don't have the toolkit anymore to actually resolve what our forefathers resolved in meetings, shook hands, did whatever they had to do, but they definitely had less conflict than we have.
Agreed. So if every project adopted one piece of common sense tomorrow, what would reduce disputes the most?
In-person meetings every 2 weeks.
Okay, so that's in effect better meetings.
Yeah, in person, not on a computer.
Okay.
In person, sitting down and actually talking to each other and finding solutions.
Excellent. And I'm going to ask you about your amazing experience throughout the years. What has adjudication taught you about people?
Ooh, they can be unnecessarily nasty when it's not required. I think
Okay. So that's how people behave when money becomes tight.
Sometimes I don't even think it's to do with that. I think adjudication has been seen in Ireland as extremely adversarial. It probably was that way in the UK. Now I don't believe in the UK. My experience quite often is it's kind of seen as a commercial reality. And you know what? We're not going to agree. So let the adjudicator decide and we move on. There's a bit more commercial common sense to it. It's not seen as adversarial in every single instance. Whereas in Ireland it is. And what I've seen, which I didn't really see as much beforehand in the likes of conciliation and negotiation, but like what one human will do to another human to win, even when the win isn't justified and they know it's not justified, like the nastiness of the human being has just come to the fore in adjudication at a level I never expected. Like what one human will do to another human to take away their livelihood. Like I've unfortunately had people come to my office who went and committed suicide because of their disputes. And I've always reflected on that, and I don't think we reflect on it enough. Like we're constantly like, we'll have like health and safety week, and we'll have this and we'll have that, and but what we do to each other as humans, sometimes we got to reflect on that and say, that's just wrong. There's no justification for that in what is a commercial dispute. Like, why drive people to that position? Why drive that cesspit of hate when it's not necessary? When the systems are there to decide right and wrong, we don't need to double down on that as humans and just be nasty human beings. And I think that's the biggest thing that has taken me by surprise when we, through the adjudication process, is just what one human will do to another, which we just didn't see, I suppose, because conciliation at its more kind of collaboratively, softly approach. And arbitration, I suppose, was going on behind closed doors, and we wouldn't have seen as much of it. It was, so it's just because it's in your face, and I suppose I'm more involved in it. I'm just taken aback with that aspect of human nature, that we just have no nature at times, that we just, as you said, common sense is not always common. Well,
so I can see disputes has definitely changed your view of human behavior. So we've looked at one spectrum, the nastiness. I'm going to ask, on the positive side of things, what qualities do the best project leaders possess?
the people, I've always said leaders, and it doesn't matter where they are in terms of construction, wherever. The best leaders I've always seen them is the people who treat people like, they empower people, they bring people on the journey, and doesn't matter what that journey is, that collaborative approach. I know we all talk about it in this ideology of like collaboration and all, but when you see it in operation, when you see somebody who's able to control the room through collaboration, where it's not like they're sitting up on a pulpit, but they're able to command that respect, and there's respect for them, that they bring everybody along, that problems are seen as inevitable, but that they're focused on, well, what's the solution, as opposed to the blame game, which is what quite often bad managers do, is they automatically, something happens and they need to deflect blame. Whereas good leaders, that's an issue for tomorrow. That's not an issue for today, because that's impacting our project. So when you see really good people where they're able to kind of come into a room and say, lads, stop, where's the fix?
Yes.
Concentrate on the fix. We've all the time in the world. We're not able to undo what's happened. So we can talk about that again. But what's the fix? They're the people, they are the leaders that I like. They're the clients I love. They are the clients who, you're happy to have meetings with them, because they're empowering meetings. They're positive people, even though they might be coming to you in a negative situation. They exude that confidence, that power, and it's infectious. And that's what makes a good leader, is just, having confidence in yourself to look at the tomorrow as opposed to the yesterday. And I think that's a powerful trait that just comes naturally to some people and not to others.
And that's an amazing advice, because the way I'm looking at it, every young quantity surveyor, engineer, project manager, and contract administrator need to understand about these skills and these aspects. You mentioned earlier that if we have better communication, we will avoid a number of disputes. And you also said about, there is more technology. Now we have a lot of AI, we have a lot of modern contracting and different forms of technology. Learning these is mandatory now. It's not kind of, nice to have. You've got to know how to deal with these things. Do you think the advent of technology, AI, modern contracting, and hopefully more standard form of contracting in Ireland will help reduce payment disputes?
No would be the easiest answer for me to give. I think the problem that technology has created is that it has created more paper. It's digital paper, but it's creating more data. It's creating like we communicate more than we ever did. We're just not doing it right. And that's the problem. So like we send each other 10,000 emails on a project, but it's how we come up with ways of collecting that data, identifying that data, managing that data, so that when an issue arises, the answer is there. Like we quite often we're creating the answer, we just can't find it because of the amount of data we're creating. I think there's certain parts of our industry will always benefit from AI. A lot of our paperwork, the clarity, but the problem you have is then when the human tries to mess with that, i.e., here's a contract, well, I'm going to go in and change every bit of it. But AI told us this is the fairest contract, or this is the way to do this, but I'm going to go in and change it. And then how does that happen? How is that dealt with? Okay. Going back to what I said earlier on, how we speak to each other when we need to, how we sit down and trash out problems. AI will never fix that. If anything, it's going to drive us further apart as communicators, as the way we were built. So it's how those issues are resolved, I think, and I suppose the interaction between the common sense, because computers won't always have common sense. That interaction between common sense and the computer will be an interesting learning curve into the future. It'll be interesting to see, what it does fix, what I hope it doesn't do. And my concern with AI in the dispute space was probably along the lines of what we saw in the likes of the PayPals and different things in the past, where the computer replaced the human and kind of gave the parties an answer based on statistical data and different things like that, which effectively brought the answer down the middle. Or, salami sliced in some way, and here's your answer. What it doesn't give is rationale. It doesn't give learning. It doesn't prevent it happening again, because the parties aren't learning from that. So what I hope AI does is it doesn't replace the necessity to learn from mistakes, so that the mistakes aren't made again. And that's what ADR gives parties, because it gives them a reasoned understanding as to why they've lost, and they can learn from that, and both parties learn from that in the future. How can AI give you that? And that's the bit, that's my concern. That's my unknown.
Respected. We've discussed quite a number of things. We've discussed better communication. We've discussed physical meeting. We've discussed records. We've discussed paper, humans, commonalities amongst them. So if every contractor, consultant, client, project manager, quantity surveyor listening today remembers from our discussion one piece of common sense, what would you want it to be?
When an issue arises today, you can't fix that has happened. And what you should be focused on is the tomorrow, and how do I fix this issue, and not stay away from the spending all of the time immediately trying to find the blame. Communicate with everybody, bring everybody together, find a solution, find the fix, and worry about the point and blame later on. Because what you're going to do is save time, save money, and make the dispute more like a seed than an oak tree.
Keith, thank you for sharing your journey, and more importantly, the practical lessons that I've learned along the way. I mean, I'm honestly reminded that while contracts, legal processes, dispute resolution systems, payment disputes, all of this are rooted in communication, trust, leadership, and everyday decisions that we make on projects. So thank you so much for coming on Common Sense Not So Common. And I'm hoping that the adjudication system in Ireland will get on its feet as soon as possible, and people like you who do immense, you know, sacrifice in terms of raising the awareness and in terms of making sure that everybody gets what they are due. Thank you so much for that.
Nazir, it's been an absolute pleasure being on with you, and I wish you well with the podcast going forward.
Thank you. Thank you, Keith.
Thank you.